Chapter 12 of the nature of the liabilities of the parties. Section 119. In general, the different parties to negotiable instruments have different liabilities. Some parties are primarily liable, while others are secondarily liable. The negotiable instruments law provides, the person primarily liable on an instrument is the person who by the terms of the instrument is absolutely required to pay the same. All other parties are secondarily liable. This is also the law generally. Section 120. Maker. As to the liability of the maker of a negotiable instrument, the negotiable instruments law provides, the maker of a negotiable instrument by making it engages that he will pay it according to its tenor and admits the existence of the payee and his then capacity to endorse. He not only promises the payee to pay it according to its tenor, but he promises any subsequent holder who is legally entitled to the instrument the same. When the instrument is payable to bearer, it is not necessary that the name of everyone through whose hands it passes should appear on the instrument, because it is made payable to bearer. Anyone bearing the paper can recover against any party on the instrument, the maker, the payee or any of the endorsers. In order to recover against one who has made it payable specially to someone, it is necessary to prove the signature of the one who has made it payable and the signature of the one to whose order it is made payable, and also the signature of any other party you are trying to recover against. The payee, when he endorses the instrument, becomes liable to parties who take the instrument after his signature is upon it. Section 121. Draw. The general law as to the liability of the drawer is clearly set out in the negotiable instruments law in the following language. The drawer by drawing the instrument admits the existence of the payee and his then capacity to endorse, and engages that on due presentment the instrument will be accepted and paid, or both, according to its tenor, and that if it be dishonored and the necessary proceedings on dishonor be duly taken, he will pay the amount thereof to the holder or to any subsequent endorser who may be compelled to pay it, but the drawer may insert in the instrument an express stipulation negativing or limiting his own liability to the holder. The drawer by signing the instrument thereby states to the payee that if he will take it to the drawee that the latter will accept it and pay it, and if he does not and the payee gives notice to the drawer of the failure on the part of the drawee, then the drawer agrees to pay it himself. He agrees to pay it if the drawee does not, provided notice in a reasonable time is given him of that fact so that he can make himself safe. The negotiable instruments law contains the following provision as to the liability of the drawer or endorser in case of a qualified acceptance. The holder may refuse to take a qualified acceptance, and if he does not obtain an unqualified acceptance, he may treat the bill as dishonored by non-acceptance. Where a qualified acceptance is taken, the drawer and endorsers are discharged from a liability on the bill, unless they have expressly or impliedly authorized the holder to take a qualified acceptance, or subsequently assent thereto. When the drawer or an endorser receives notice of a qualified acceptance, he must, within a reasonable time, express his dissent to the holder, or he will be deemed to have assented thereto. Section 122. Acceptor. The general law as to the liability of the acceptor is clearly set out in the negotiable instruments law in the following section. The acceptor by accepting the instrument engages that he will pay it according to the tenor of his acceptance, and admits, 1. The existence of the drawer, the genuineness of his signature, and his capacity and authority to draw the instrument, and, 2, the existence of the payee, and his then capacity to endorse. When the acceptor accepts it, being the drawee, he thereby says to the payee, I recognize that signature as that of the drawer, I have funds in my possession belonging to him to the amount of this instrument, and I promise that I will accept this and I do accept it, and since it is payable 10 days after sight, you bring that instrument around in 10 days and I will pay it. Now, this instrument having been endorsed by the payee to A, what is the liability of the acceptor to A? Y. The acceptor says to A, you present that instrument to me and I will pay it. I recognize that signature of the drawer, and I will vouch for that. The payee is a party who is capable and has capacity to endorse the instrument. You present the instrument to me and I will pay it. That is his contract with the endorser or holder. A. What is his contract with the drawer? It is, that he has funds in his hands belonging to the drawer, and he says to A, the drawer, you draw upon me any time and I will accept and pay the bill. If I don't, then I am liable to you in such damages as you may suffer by my refusal to accept and pay the instrument. The liability as to the endorsers on the back of the instrument is substantially the same. Other provisions as to the liability of the acceptor found in the negotiable instruments law are as follows. When the acceptor of a bill drawn in a set pays it without requiring the part bearing his acceptance to be delivered up to him, and that part at maturity is outstanding in the hands of a holder in due course, he is liable to the holder thereon, except as herein otherwise provided, where any one part of a bill drawn in a set is discharged by payment or otherwise, the whole bill is discharged. Section 123. The endorser. The endorser engages, a, that the negotiable instrument will be accepted or paid, as the case may be, according to its purport, but this engagement is conditioned upon due presentment or demand, and notice. B, that it is in every respect genuine. C, that it is the valid instrument it purports to be. D, that the ostensible parties are competent. E, and that he has good title to it and the right to endorse it. And if it turns out that any of these engagements except that first named are not fulfilled, the endorser may be sued for recovery of the original consideration which has failed, or be held liable as a party, without proof of demand and notice. The above rights inure to the holder of the bill, and he can sue upon it or further negotiate it, and though guilty of a fraud in parting with it, nevertheless he can give title to a bona fide holder for value without notice who takes it before maturity. Any irregularity, as a torn paper, or something similar, patent on the face of a bill, is equivalent to notice, and the holder who takes such an instrument will not be considered an innocent holder. In an action by the de facto holder, it may be shown that he holds adversely to the true owner, and that he is agent or trustee for another person, and then any defense or set-off available against such person is available against the holder. Every endorser who endorses without qualification warrants to all subsequent holders in due course, 1. The matter and things mentioned in subdivisions 1, 2 and 3 of the next preceding section, and, 2, that the instrument is at the time of his endorsement valid and subsisting. And, in addition, he engages that on due presentment it shall be accepted or paid, or both, as the case may be, according to its tenor, and that if it be dishonored, and the necessary proceedings on dishonor be duly taken, he will pay that amount thereof to the holder, or to any subsequent endorser who may be compelled to pay it. Where a person places his endorsement on an instrument negotiable by delivery, he incurs all the liabilities of an endorser. As respects one another, endorsers are liable prima facie in the order in which they endorse, but evidence is admissible to show that as between or among themselves they have agreed otherwise. Joint payees or joint endorsers who endorse are deemed to endorse jointly and severally. What liability does an endorser have to the preceding endorsers? He can recover against any who precede him, but none who succeed him. The endorsement or assignment of the instrument by a corporation or by an infant passes the property therein, notwithstanding that from want of capacity the corporation or infant may incur no liability thereon. In other words, the parties who have received the instrument and passed it on to someone else are estopped to set up that the other parties did not have capacity. Of course, a minor has a right to set up the defense that he himself did not have the capacity. These parties, then, guarantee or warrant the capacity of the previous parties to make the instrument, but this does not stop the party who is really incapacitated from setting that up. There is some conflict as to the liability of an endorser without recourse, but the general rule is that a person who endorses without recourse makes all warranties any other endorser does, except that he does not warrant the capacity financially of the other parties to pay. He does not agree to indemnify the other parties on the instrument. The endorser without recourse makes this representation and warranty to every person who gets the instrument, that the parties had capacity and the instrument is a valid instrument as to form, etc., but he does not warrant the financial responsibility of the parties. By placing his name there, he makes that contract with everybody who takes the instrument. When an instrument is made payable to bearer and has passed from hand to hand by mere delivery, The endorsee or holder has no right to recover from any other party who has passed it on by delivery unless that party's name appears on the instrument. There can be no recovery against the party whose name is not on the instrument, unless the party who is endeavoring to recover from him has immediately received that instrument from him. Those are the liabilities of the endorser without recourse and the endorser by mere delivery. The negotiable instruments law covers these principles in the following section. Every person negotiating an instrument by delivery or by a qualified endorsement warrants, 1. That the instrument is genuine and in all respects what it purports to be, 2. That he has a good title to it, 3. That all prior parties had capacity to contract, 4. That he has no knowledge of any fact which would impair the validity of the instrument or render it valueless. But when the negotiation is by delivery only, their warranty extends in favor of no holder other than the immediate transferee. The provisions of subdivision 3 of this section do not apply to persons negotiating public or corporate securities, other than bills and notes. There is the following provision as to the liability of an agent or broker who negotiates an instrument without endorsement. Where a broker or other agent negotiates an instrument without endorsement, he incurs all the liabilities prescribed by Section 115 of this Act, unless he discloses the name of his principal, and the fact that he is acting only as agent. Section 124. Accommodation and accommodated parties. The following provision is found in the Negotiable Instruments Law. An accommodation party is one who has signed the instrument as maker, drawer, acceptor or endorser, without receiving value therefor, and for the purpose of lending his name to some other person. Such a person is liable on the instrument to a holder for value, notwithstanding such holder at the time of taking the instrument knew him to be only an accommodation party. Here is a lending of the credit of one person to another for accommodation. A wishes to pay an obligation of $500 and he has no credit. He says to B, "Put your name on this paper and I will have money by the time it comes due and pay it and I will see that you do not suffer any damage." So B signs. When that instrument becomes due, if A does not pay and B has to, then B can recover from him. But since B has received no consideration there can be no recovery as against him by A. Suppose A lends you his credit for a special purpose and you use that credit for some other purpose and the person who takes that credit knows that it has been loaned for a particular purpose. Then the person who takes that credit cannot recover. He cannot recover because he knows that the credit has been diverted from the purpose for which it was given. He has notice. Where a bill is drawn or accepted, or a note made or endorsed for accommodation, with an agreement that it shall be used for a particular purpose, any diversion in its use operates as a discharge of the accommodation party as to all other parties who have knowledge of such diversion. It is immaterial that paper executed or endorsed for accommodation is not used in precise conformity with agreement, when it does not appear that the accommodation party had any interest in the manner in which the paper was to be applied. No change in the mere mode or plan of raising the money, though not applied to the purpose intended by the accommodation party, will constitute a misappropriation. In order to constitute a misappropriation, there must be a fraudulent diversion from the original object and design, and it is now well settled that where a note is endorsed for the accommodation of the maker, to be discounted at a particular bank, it is no fraudulent misappropriation of the note, if it is discounted at another bank or used in the payment of a debt or otherwise for the credit of the maker. If the note has effected the substantial purpose for which it was designed by the parties, an accommodation maker or endorser cannot object that the accommodation was not effected in the precise manner contemplated, where there is no fraud, and the interest of the endorser is not prejudiced. It is the general rule that an accommodation party lends his credit only for the period specified in the instrument, that is, until its maturity, and if transferred thereafter such party should not be made liable except as an ordinary party to commercial paper. The presumption is that such an endorser is subject to the same liabilities as are imposed by the statute upon general endorsers, and their rights are largely the same. Thus one endorsing an instrument for the accommodation of the maker cannot be charged without a demand. While a corporation has, under certain circumstances, the general power to bind itself by promissory notes and contracts of endorsement, made in the general course of its business, it has no power to make or endorse notes for the accommodation of others. The validity of such paper can also be assailed upon the theory that the officer of a corporation who executes it cannot so bind the corporation in a matter not connected with its business, or in which it has no beneficial interest. But in the hands of a bona fide purchaser for value, accommodation paper duly executed by the officers of a corporation can be enforced against the corporation. The rules applicable to the rights of bona fide holders of accommodation paper, signed by one of a partnership without the consent of his co-partners, can also be applied in the case of similar paper executed by the officers of a corporation. Successive accommodation parties are liable to each other in succession, according to the order in which their names appear upon the instrument. The reason for this rule may be found in the presumption that each accommodation endorser placed his name upon the instrument trusting in the strength of the prior accommodation endorsers. Facts may be shown as in the case of other endorsers to show that the liability is joint because of an agreement between them to be bound jointly and not severally. If no such agreement is shown, such endorsers are not co-sureties and there can be no right of contribution among them.